I'm Doug Maitland. I'm with the ODOT Office of Real Estate, and this is the fourth module in the Value Finding module series. In this module, we'll be introducing to you the Value Finding Appraisal Report. The general points for the Value Finding Appraisal Report are: it's only used for partial takings where the acquiring agency has the power of eminent domain. It's a valuation template used by ODOT, and the form is RE90. It is an appraisal, and because it's an appraisal review is required. It has to be USPAP compliant. USPAP's the acronym for Uniform Standards of Professional Appraisal Practice. It's used when there's an uncomplicated valuation problem that exceeds the limits of a waiver valuation. Means that it must be abundantly clear that there are no damages to the residue. If damages are questionable, do not use this format. The limits of compensation are $65,000 or less. The value finding report is only used because prior to the appraiser's analysis and development of the valuation estimate and the compensation estimate that are detailed in the value finding report, the acquiring agency has developed the appraisal scoping checklist. This checklist allows the agency to contribute to the appraisal process to assure the appraisals it receives are relevant to its program needs in accordance with federal regulation, which is 49 CFR Part 24, and have been completed by people having sufficient competency to understand that the taking from the whole is an uncomplicated valuation problem, that it's clear the residue suffers no loss in value, and that its highest and best use remains as it was before the taking, and that the anticipated amount of compensation is no greater than $65,000. When these conditions are met and documented on the appraisal scoping checklist, it's appropriate to use the Value Finding Appraisal Report. So here's the first page of the Value Finding Appraisal Report. Almost everything on this page is going to be auto-populated from other pages on the VF template. It's developed to comply with USPAP, with 49 CFR Part 24, and with the Ohio Administrative Code. This first bracket is the summary of compensation. It includes land taken, site improvements taken, any nominal cost secured, temporary easements, and the total of those is the estimate of compensation. The next bracket is a summary of salient facts. The third bracket summarizes the takings. The fourth bracket summarizes the effect of the takings on the residue property. And the last item on this page is the appraiser's estimate of compensation as of the effective date of the appraisal. Throughout the value finding report, you're going to see on the left-hand side the USPAP standards rule. In this case, it's pointing at Standards Rule 2-2AI, and that's followed by the actual USPAP citation, which would be state the identity of the client. And underneath that is the agency or the appraiser's response to summarize a response to the USPAP requirement. In this case, the client is the Ohio Department of Transportation. Where you see a gray area on this form, you can write in that area. Otherwise, the form is auto-populated. So you can see under Standards Rule 2-2A III to state the intended use of the appraisal. You cannot go in and change that. That is auto-populated. And again, where the gray areas are at, the appraiser is expected to go in there and fill in the appropriate information. All right, so now we're going to go to page 2, and we're going to start reviewing the form. So the first standards rule is 2-2AI, state the identity of the client. And the client is ODOT or it's an LPA. Standards rule 2-2AI is state the identity of any other intended users by name or type. And the intended users are ODOT, the Attorney General's Office, courts, the property owner, and we're disclosing that this value finding report could be a public record. Next USPAP standard is 2-2A III, state the intended use of the appraisal. Upon approval by ODOT, the value finding will be the basis of FMVE, and it's given to the owner during the negotiation process. Next USPAP standard 2-2A-IV, the appraisal report contains information, documents, and other exhibits sufficient to identify the real estate involved in the appraisal, including the physical, legal, and economic property characteristics relevant to the assignment. So the appraiser is to discuss the whole property in this area. More information about physical, legal, and economic characteristics are further discussed in the highest and best use section of this report, the attachment section, and the summary of taking. Next USPAP standard 2-2AV, state the real property interest being appraised. And in this case, it's the fee simple estate. Next standard 2-2AV. AVI, state the type and definition of value and cite the source of the definition. The definition of value that ODOT uses in its eminent domain valuation formats is from the Ohio jury instruction, and the citation is there in the second paragraph. And what follows next is the actual Ohio jury instruction definition of value, which is recited in this paragraph and goes on to page 3. It's a statement that FMVE ignores project influence, which is in compliance with federal and state regulation. And the next paragraph is the actual citation requiring the agency to ignore project influence in its before valuation. The next USPAP standard, 2-1CIV, when reasonable exposure time is a component of the definition of the value opinion being developed, the appraiser must also develop an opinion of reasonable exposure time linked to that value opinion. We're going to state the exposure time. And this can be a confusing issue for people. And so what I've just inserted here comes from USPAP. Uniform Standards of Professional Practice defines exposure time as the estimated length of time that a property interest being appraised would have been offered on the market prior to the hypothetical consummation of a sale at market value on the effective date of the appraisal. Next USPAP standard, 2-2AVII, state the effective date of the appraisal and the date of the report. The effective date of the appraisal is generally the date that the appraiser inspected the property. In an appropriation setting, it could be a date established by the court or the date that the agency actually set foot on the property. For our purposes, it's going to be the date that the appraiser inspected the property. The date of the report is actually the date that the appraiser signed and completed the appraisal report. Next USPAP standard, 2-2AVII, summarize the scope of work used to develop the appraisal. The value finding is a limited scope appraisal. The residue of the whole is not damaged by the take, therefore, the scope is limited to an analysis to an estimate for the unit value of the whole property as a vacant site. Now moving on to page 4, and we're continuing with the summarize the scope used to develop the appraisal and the USPAP standards. Next paragraph, we're going to talk about the appraisal scoping checklist as part of the scope. It's the justification by ODOT to use the value finding appraisal report. Next paragraph is the comparable sales portion of the scope. It's a land-only appraisal using the sales comparison approach to value the whole. The next part of the scope is the scope of work is limited to a fractional interest. The appraiser must disclose the existence of improvements on the property, even though the improvements are not valued. And this is where the appraiser has to insert something because it's asking, state if there are structures or improvements not considered. So the appraiser then has to state if there are or not improvements that are not considered in the scope of work. And those would be improvements outside the take area. For example, you've got a house sitting on a small acreage tract, and ODOT's taking a small clip along the road frontage, not even touching the house. And so we're going to focus on the take area, which is that small strip take. We're going to value the site as if vacant. We're not going to consider that house that is outside the take area, and that can be misunderstood by the casual user of this appraisal report. So the appraiser has to disclose that that house, which is outside the take area, is not considered in this appraisal report. Next, use PAP standard 2-2AIX, summarize the extent of any significant real property appraisal assistance. And so the appraiser is expected to check if anyone has provided appraisal assistance, and if they did, the appraiser has to elaborate on what occurred. Next, use PAP standard 2-2AX1, summarize the appraisal method and techniques employed. The sales comparison approach is used to estimate the unit value of the whole. The income approach is to estimate land rent for any temporary construction easements. The cost approach is used to estimate the contributory value of site improvements taken. Next, use PAP standard 2-2AX2. State the reasons for excluding the sales comparison, cost, or income approaches, if any have not been developed. And a summary of this is the scope of work is limited to the unit value of the land as a whole. There is no valuation of structures outside the take areas. The sales comparison approach, cost approach, and income approach is to value the entirety of the whole, inclusive of structures, is inappropriate. We're on page 5 of the value finding report now. Next use PAP standard is Standards Rule 2-2AX3, which is summarize the results of analyzing the subject sales that occurred within 5 years prior to the effective date of appraisal per Standards Rule 2-5B, agreements for sale, options, and listings in accordance with Standards Rule 1-5. There's a little explanation here is that the typical use PAP standards require a 3-year sales history, but the federal regulation requires a 5-year sales history. So in this case, we go with the greater standard, which is the federal regulation, and so we require the appraiser to analyze a 5-year sales history. Next use PAP standard is Standards Rule 2-2AX4, state the value opinions and conclusions. The first one is the unit value for the whole property as a vacant site before the taking, based on the hypothetical condition of ignoring project influence. That is usually at a price per acre or a price per square foot. Next is the allocation of that unit value to the land taken. Next would be site improvements. Their value is based on the contributory value that they would have to the whole property. Next would be any nominal cost to cure, which may be needed to mitigate damages to the residue or the potential for damages to the residue. Next are temporary easements taken. It's based on the assumption that the unit value of the land component of the whole property is the same for the residue property. And the total of all those would be the total fair market value estimate for compensation. Now, all of this information is auto-populated from elsewhere in the Value Finding Appraisal Report. Next use PAP standard is 2-2AX5, which is summarize the information analyzed and the reasoning that supports the analysis, opinions, and conclusions, including the reconciliation of the data and approaches. Now moving on to page 6. So the first part of the summary of information is evaluation of the whole as a vacant site before the taking, followed by the sales grid. The grid is used to compare land sales that are similar to the whole to derive a unit value for the whole. Again, considering the whole as a vacant site in its condition before the taking, ignoring any influence from the pending highway project. The appraiser summarizes their analysis of the sales and reconciles the data and analysis in this area below the grid. And ultimately, the appraiser is going to conclude and state the unit of value for the whole property as a vacant site, which is then followed by the estimated compensation for land or property rights that are taken is developed in this part of the form. Using the value of the whole, the appraiser allocates the unit of value to the land taken. Moving on to page 7. The very top bleeds over from page 6, and it's the conclusion of the fair market value for land taken, followed by the analysis of site improvements taken. And the estimated compensation for site improvements taken is developed in this area outlined by the blue square. It requires the appraiser to provide supporting analysis for the compensation and requires supporting cost data to be in the attachment section of the value finding report. And at the end of all this, the appraiser states the estimated compensation for site improvements taken. The next area is analysis of the nominal cost to cure. And at the end of that analysis, the appraiser estimates compensation for any cost to cure, which is followed by an analysis of any temporary easements taken. We're now on page 8. The very top of that bleeds over from page 7, which is the conclusion of the temporary easement analysis. And the appraiser states the estimated compensation for any temporaries. And at the end of all that is the fair market value estimate of total compensation. This is also known as the appraiser's estimate of FMVE. This does not establish FMVE. That is the agency's decision to use this appraisal after it has been reviewed and recommended. Next section. Describe the takings and summarize the effect of the takes on the residue property. This part focuses on the residue and it requires the appraiser to describe the takings, state the gross and net areas of the residue, describe and analyze the effect of the takings on the residue property, state if the residue has severance damages, and state if there's any information from the title report that affects the valuation of the property. The next section of the value finding report complies with Standards Rule 2-2AXI, which is stating the uses of the property, and then followed by 2-2AXII, which is dealing with the highest and best use of the property. We're running out of room on this page to discuss, so we're going to focus on this area outlined in blue on the next page, page 9. All right, so this is a continuation of page 8. We're going back to the blue area. The USPAP standard is Standards Rule 2-2AXI. State the use of the real estate existing as of the effective date and use of the real estate reflected in the appraisal. So we have to state the use of the real estate as of the effective date, or as an example, property could be improved with a house. And so the use of the real estate would be single-family residential use. But we're also to state the use of the real estate reflected in the appraisal. And in the value finding appraisal report, we often ignore any structures outside the take area. So in that case, the use of the real estate reflected in the appraisal would be a vacant site. Standards Rule 2-2AXII. State the appraiser's opinion of highest and best use and summarize and support the rationale for that opinion. And so we have to state the highest and best use and summarize the support and rationale in this area. Now we're going to page 9, still under highest and best use. We put in the utility information and then summarize all that information and put a statement on what the highest and best use of the site is, and then the highest and best use, we're going to summarize the appraiser's analysis of highest and best use, and then we're going to state what the highest and best use of that site is. Moving on to the next USPAP standard, Standards Rule 2-2AXV. Clearly and conspicuously state all extraordinary assumptions and conditions and state that their use might have affected the assignment results. So this first section deals with extraordinary assumptions. So we have to state any extraordinary assumptions and state that their use may have affected the results of the assignment. And the definition of what an extraordinary assumption is, it is uncertain information in the analysis which, if found to be false, could alter the appraiser's opinions and conclusions. If the appraiser is going to use an extraordinary assumption, the district office must pre-approve that extraordinary assumption before the appraiser uses it in the appraisal report. There are two standard extraordinary assumptions used in the VF reports, and the appraiser may add as many others as are needed. The first one, that is the standard assumption, is the temporary construction easement is based on the residue. And with a value finding, the residue isn't valued. It's assumed that the unit value of the site is the same for the whole and for the residue. And the second assumption is damages are determined by the loss in value of the residue. With the value finding, the residue isn't valued because the valuation problem is determined to be uncomplicated, and the highest and best use of the site is assumed to be the same for the whole and the residue. The next one we're going to deal with are hypothetical conditions. So we have to state any hypothetical conditions and state that their use may have affected assignment results. So now on to page 10, and the hypothetical conditions continue. And a hypothetical condition, as defined in USPAP, it is a condition which is contrary to what is known to exist but is used for the purpose of analysis. Hypothetical conditions can only be used if they're required for a legal purpose, for purposes of reasonable analysis, and for purposes of comparison. There's one standard hypothetical in all value finding appraisal reports. District offices also must pre-approve any hypothetical conditions before the appraiser completes the appraisal report. The appraiser may add as many as are needed that are pre-approved by the district. And the standard hypothetical that we use is, as a legal requirement, the appraiser must ignore any enhancement or decline in the value of the whole caused by the influence of the project. Finally, Standards Rule 2-2AXVI, USPAP requires that the appraiser include a signed certificate in accordance with Standards Rule 2-3, and we have added 49 CFR 24.103A2V and the Ohio Administrative Code 5501 2-506 C1V. So any value finding must have a signed certificate. The certificate must be in accordance with USPAP Standards Rule 2-3 and the regulations governing the acquisition of rights-of-way for highway projects. So here is that certificate that ODOT has created for value finding appraisal reports. Number one, the date that the appraiser inspected the property. Number two, owner accompaniment. Number three, the appraiser inspected the comps. Number four, the appraiser has to comply with 23 CFR Part 710 and 49 CFR Part 24. Just a brief explanation on those regulations. Often, ODOT uses highway trust funds from the federal government in its projects. If there are any highway trust funds in any part of the project, the entire real estate acquisition process, including appraisals, has to comply with the federal regulations. 23 CFR governs FHWA, who's responsible for monitoring the highway trust funds. Part 710 deals with real estate acquisition. So therefore, any real estate appraisal has to comply with the requirements of 23 CFR Part 710 because federal highway funds are used in our projects. The second regulation is 49 CFR Part 24. Any project having federal regulations has to comply with the Uniform Act. And 49 CFR Part 24 is the regulation that implements the Uniform Act. Number 5. The appraisal and compensation have to comply with the laws and regulations in the state of Ohio. That would include case law governing what is not compensable, the Ohio Constitution in particular, Article 1, Section 19, and the Ohio Administrative Code. That is the section of the code that governs the director of the Ohio Department of Transportation and is this eminent domain power that ODOT has. Our real estate appraisal process also has to comply with eminent domain law, which is Chapter 163 of the Ohio Revised Code. Number 6, the appraisal has to comply with USPAP. Number 7, that the statements in this VF are true and correct. Number 8, the opinions and conclusions of the appraiser are unbiased. Number 9, the appraiser can never have had an interest in the property or with the parties involved. Number 10, the appraiser has no bias with the property. Page 12, certificate of appraiser continuing. Number 11 and 12, the appraiser's engagement for the assignment or for the compensation for the assignment is not contingent on reporting predetermined results. Number 13, disclosing if anyone did or did not provide appraisal assistance. Number 14, disclosing if the appraiser performed any services regarding the property appraised within the last 3 years. Now, number 15, 16, 17, 18, 19, and 20 deal with another section of Ohio Revised Code. It's Ohio Revised Code, Chapter 4763. Any appraiser who is licensed or certified has to comply with that chapter of Ohio Revised Code because that is the chapter that governs certifications and licensure of appraisals in the state of Ohio. To comply those regulations governing appraisers, we've included 15, 16, 17, 18, 19, and 20 to assure that the appraisers put into these value finding reports that which is legally necessary. So the appraiser has to disclose if that person is certified or licensed as an appraiser, which would include the name on the certificate, the class of the certification, the certificate number, and disclosing if the report is within the scope of certification. Disclose if the appraiser is a consultant or an ODOT employee and that they have no interest or bias regarding the property. Finally, at the end of the certificate of appraisal, the appraiser has to type their name and sign it and date the report, which is also required by USPAP, Standards Rule 2-2 AVII. All right, now the last part of the Value Finding Appraisal Report are the required attachments to the Value Finding Appraisal Report. And they include the signed appraisal scoping checklist, sketch or sketches, photographs including an aerial, location map, sale data sheets, support for contributory value of site improvements taken, support for any nominal costs to cure, and anything else considered pertinent. It's time for a knowledge check.